Okay, everybody, welcome back. We're into week 4, and we're going to talk this week about investigations law. And I know several of you in the course have taken my course in investigations, in corporate security investigations, and so there'll be there's going to be necessarily some repeat of information. However, we're really putting the spin on it this week with how case law especially impacts investigations and how you need to understand and be current on case law when you're an investigator. And so there'll be some repeat of some concepts, and I apologize for that, but they are necessarily associated, so that's going to happen. But before we jump into that, let's talk a little bit about last week's quiz, because there were a lot of you that had some questions about the quiz, and so let me just give you a little bit of information. So first, let me confirm what you already know, that for many, my quizzes are not easy. First off, some people don't like taking quizzes, and I will readily admit I'm one of those people. However, we need to have different ways to assess whether you have done the work and whether you understand the work in the course, and quizzes are one way we do that. I normally do it with quizzes and discussions, and sometimes projects, and we'll do a small group project at the end of this course. But primarily, discussions and quizzes are the way we do that. I don't purposely try to make them hard, but I do want to make sure that you understand the material and that you have actually done the work. It's all part of the process, right? I design the quizzes and then I monitor them each semester. I pretty much use the same types of questions. I don't rehash my quizzes from one semester to the next, but I may take it's the same information in the same course, right, for each unit. And so the quizzes are going to be generally similar because they have the same important information, right? But I may just go in and change and add the word not to a true-false question and change the answer. I may reword a question. I may take out some of the wrong choices and put in different ones that are closer to the right answer or farther from the right answer. But what I do is I look at each quiz and I look at each question. D2L has some pretty good statistics for quizzes, especially when you use multiple choice and true-false. And it will tell me how many people missed a particular question, how many different answers they gave. So if it's 4 answers to a multiple choice question and all 4 were checked across the board by people, then I know that perhaps those wrong answers might just be too close to the right answer. But I monitor it very closely. If a question, and I go again after every quiz is in, I go in and look at the statistics, and it shows every one of your names, what you got, and I can go in and see which questions you missed. It's not a hard exercise to do. But if the entire class missed more than 50% of the entire class missed a single question, then I go in and I make sure that I have either a direct quote in the lecture or the reading or somewhere that substantiates the answer that I gave. If indeed it's a true-false and everybody checked false and the answer is true, then I will go through and make sure that we have a direct quote that would support the true answer. And if it's not there, then I will discount that question. I've done it in the past. Sometimes I tell you, sometimes I don't. Sometimes you'll just see your grade went up. It'll never go down. But it went up because I discounted a question and you happen to get that one wrong, and so you're given credit for it. But it really needs to be more than 50% of the class. We have not seen that in this quiz, and I have not seen that in a very long time. But I do look at those. The class average grade on my quizzes almost always falls between 80 and 83%. There was one recently that went up as high as 88. But basically, I don't give you a quiz where the class average is going to be an A. That's something called grade inflation. It is something that doesn't give those students who take the time and effort to study and to do their work, it doesn't give them the recognition they need. Nor does it tell me if someone's really struggling in the course, even though they may be putting in that preparation. If everybody gets an A, then everybody might as well get an F, right? The old saying, if everything's a 10, then everything is actually a 1. It's all the same. That's not how life works, but my quizzes tend to be between 80 and 83%. I don't plan it that way. There's no way I can plan it that way. It just keeps happening. And it's consistent across all the courses I teach when I give quizzes. It makes me scratch my head, but that's kind of a sweet spot that I think is appropriate, A, B. And, you absolutely have the chance to move from a B to an A with your discussions, which means that if you're not a great quiz taker, then you need to really concentrate on your discussions. And if you are a good quiz taker, then perhaps, you don't need to concentrate as hard on the discussions if you're a B's get degrees kind of person. But an 82 and 83 is where they fall. That's a B, and a B to me says that quiz is appropriately tough, but it's also fair. Now, a couple of you called me this week and asked if you could see what questions you missed, and I have, sometimes I'll talk to you on the phone about that. But look, I really do want to make sure that you understand things that you missed, so you understand why you missed them, especially if it's a building block for another part of the course. But at the same token, I wasn't born yesterday. If I give you on Monday the answers to the quiz, things you missed, and help you get those right, by Tuesday, there's the potential for 3 of your friends to have those answers, and by Thursday, the entire class has got access to them, at least if they wanted them. So, we're not going to try that. But after a quiz is over, if indeed you want to understand what you missed, I would suggest if you missed a question, you go back and just research it and find out what the real answer to that question is. I mean, you do have access to that, but anyway, that's the quizzes. They are going to be, I won't say tough, but they're going to be fair and challenging. And that's kind of how life works, guys. So if you do have questions on the quiz, if you don't do well on quizzes, just do better on the discussions. I have had people who have gotten consistently 70% on their quizzes, and they've gotten an A out of the course because the points can add up that way if you do good work on the other stuff. So that's it with quizzes. Did have a lot of inquiries this week about the quiz, so just wanted to clear that up for you. So on to this week, we're talking about investigations law, and kind of part and parcel to that is negligent hiring law, because background checks really are an investigation of sorts. It's the initial investigation you do in someone, or that someone does, and we'll talk a little bit about that. But they kind of go hand in hand a little bit. So we're going to talk about both just briefly on the negligent hiring. We're going to take a little more of a deep dive into the cases, and I've selected cases, but there are thousands of cases that could give you the same answer or maybe a slightly different answer. But these cases really kind of give you some information. If you read the case, if you brief the case and you understand it, you would come up with the same examples that I did as to what this teaches you as a security investigator and as a security manager who does investigations, which is normally the case, and how you would react to that. This week, you're all going to prepare a case brief, an opinion brief, and you'll be assigned court opinions. You don't all have the same one, so you'll need to do that, but you're going to be responsible for all the cases that are briefed and discussed. This is not a law school course. I'm not going to say, give me your interpretation of, Slippery Rock versus Wisniewski. It's not going to happen. However, the concepts are something that you need to understand, and you will be able to go back, obviously, in any quiz or test in this class and look at reference material, which in this case is your classmates are going to write briefs. So if you want to read the whole court case, most of them are opinions. Most of them are pretty short for this course. They're from the text mostly. I try not to find opinions that are 50 pages long because they tend to just get too complex and they answer too many questions before the court. Court oftentimes has to answer 5 or 6 questions that come to them, especially in appeals court. So I try to look for shorter opinions. So you can read the whole thing, but if you read the case briefs from each case that's assigned to the class, in this case, I believe there are 5 or 6 cases that I've spread out over the 30 or so of you to brief on. And if you read those briefs from a student that you can enjoy and understand their writing style, and you trust their work, then that will help you. And that's kind of how the best way to study for these things. So you're responsible for all the cases, not just the one that you write on. In a quiz going forward, you will see mention of a case that you have not written a brief on and that we have not talked about in the lecture. Other students have briefed it. They've posted it to the discussion board. You are responsible for the basic understanding of that, at least being able to answer a basic quiz question on it. So as we talked a little bit about in the investigations course, a poor investigation, it's seldom going to get you arrested. I mean, I guess it could, right? I mean, if you did something totally illegal against a law in your investigation, right? You were doing a corporate security investigation into the theft of paper from the copy machine, and you decided to call somebody in to interrogate them, which we don't do, we interview, but you call them in to interrogate them and you beat them with a stick, then you will probably get arrested as a result of something you did in your investigation. But a poor investigation will sometimes get you sued, and that's normally a wrongful termination suit. Because the investigation resulted in someone's termination from employment. They believe they've been wrong. They believe that your investigation was not proper in some way. And we'll talk about a few of the ways that can happen. And so you'll sometimes get sued. A poor investigation is often going to get you into trouble, though. And when I say trouble, it's going to hurt your reputation in the workplace, and it's going to certainly breed some distrust among the employee population. If you don't do good and fair investigations, then people aren't going to stick around, quite frankly. They see that there's the witch hunts that go on in investigations sometimes. But most important to me, anyways, a poor investigation creates another victim. So, you have someone who alleges that something was stolen from their office, and that person is a victim. And if you do a poor investigation and you wrong someone by having them terminated, accusing them, then you've just created another victim. If our job is protective services, and that's exactly what it is, we protect everyone. We even protect the perpetrator to make sure that they get fairness in an investigation, right? We remain objective. And a poor investigation just creates another victim. And that is just multiplying our work and moving far away from what our intended purpose is as a security professional. So when we look at case law and we look at investigations, at workplace investigations, and many of these, as you read cases, the investigation was done by an HR person or by inside counsel, a lawyer at a company. They commonly do a lot of investigations. Most of the literature, frankly, on investigations is written around HR people doing the investigations. I won't talk in anecdotes, but I will say that there is very little in an HR education that teaches you about investigations. In fact, I would say that this isn't anecdotal because I've looked at several leading HR programs, and they very seldom talk about workplace investigations, yet workplace investigations normally get reported to HR, and so naturally they say, okay, it's been reported to us, we need to do something, so we're going to do it. That can be good and bad, right? But as you read the cases, you'll see the HR person did the investigation, or the inside counsel, the lawyer for the company, did the investigation. It's simply because that's where those are reported, and they feel like they must run with the ball. When somebody hands you the ball, you feel like you have to do something with it. But oftentimes, cases are investigated by the security manager in a workplace. Some of the common mistakes when we look at these cases, we find that unqualified investigators are a real problem. And we're going to talk a little bit about a case that it's actually a municipal case with a workplace twist. Incomplete investigations and delayed investigations, those are really, that half-baked investigation, if you will. I've coupled those together in a single case because I think it's a good double whammy to explain those. And then retaliation, huge issue in investigations. Investigations are used as a tool to find the truth. They're also used as a tool like a club to hit somebody in the workplace. And you've got to be very careful as a security manager that you don't fall into that trap. So let's look at, let's start with unqualified investigators and see what we learn from just one court case we'll discuss. So in this particular case, Kramer versus Wasatch County Sheriff's Office. Wasatch County is a relatively small county in rural Utah, population 20 to 25,000 in the entire county. County seat, Heber City. I actually was stationed with somebody in the military from Heber City, Utah. He was very proud of the fact that he came from the big city, that he was a city boy because he came from Heber City, which is a population probably 12,000. But it's a very small county with a relatively small sheriff's department, right? We all know them. There are 100 of them plus probably across Pennsylvania. I know in Michigan, if you take Kent County and Oakland and Wayne County, Macomb County, those four big counties that make up the vast majority of our population, and then maybe the counties around Flint and Saginaw. We have 83 counties. Probably 75 of them are of the same size and scope when it comes to these sheriff's departments. Now, Kramer was a sheriff's department employee, and she worked in various jobs. She was a jailer for a while, a matron, I think was the term they used, if I'm not mistaken, in the county jail. She did administrative tasks. She really wanted to be on road patrol. And Kramer was not without fault, or I don't want to say that. She was not a perfect human being, and none of us are. Kramer had some history of dating coworkers. She had some history. She had a child by a married coworker. Actually, he was a firefighter, I believe. But there were many, many twists to this. But it's a classic case of Kramer was being sexually harassed, and in fact was raped by a person who was in a superior position. Although there was some, Title VII, the control issue in Title VII in employment law, basically says what a supervisor is, and there was some discussion on that in the case. But Kramer was definitely someone who was harassed and literally abused in the workplace. She was not given any of the assignments that she probably worked for and deserved. But she filed a sexual harassment complaint after a very long series of abusive acts by coworkers, not just one, but by many. When the complaint was filed, the sheriff assigned a new detective to investigate this. He had no experience in workplace matters. Now, he's a detective, and you would think, oh, detective, that's an investigator, right? We use those words interchangeably. But this was a workplace investigation, and the detective had no experience at all in workplace investigations. And the investigation quickly turned to an investigation into Kramer's past, her past sexual relationships, her past relationships with coworkers. It really turned into a witch hunt on Kramer. And the detective eventually went to Kramer and said, look, I've got, all of this negative information that's going to come out on you. Maybe it's best if you just resign and move on, which is what Kramer did. She basically felt defeated and left. Now, there are so many things wrong with this particular case that it just makes your head spin. And if it doesn't make you mad, then maybe you're in the wrong game, because it should make you mad that people are treated like that in the workplace. But there were some quotes from the appeal on this case, and the case was appealed, due to the size of the judgment and other things. But one of the two that really stuck out for us as security investigators, the sheriff did not consult the county's human resources professional about the allegations, and didn't ask for any, what do we do? What's our policy, right? And in fact, the sheriff was quoted as saying, "Why, when asked, why did you assign that detective, a new detective, to this?" He said he was the unfortunate guy that was on duty on that particular day. Now, you needed a workplace investigator who had some training or expertise or understanding of sexual harassment in the workplace issues, right? Someone who could review EEOC guidelines, someone who could understand state and law on this. But a detective is great at what he does. The saying I use all the time is, they were dying of thirst and somebody handed them a sandwich, right? I mean, it's still good, but it doesn't solve the problem. And the sheriff didn't give the directive any policy or procedures, because he never went to ask for any. And to tell the truth, I've read the case a couple times. I don't recall ever seeing that they had any. But he didn't have any parameters on which to conduct the investigation. Now, again, those of you who have taken the investigations course know that you have to have a rule or policy or a law that's been violated, right, in order to do an investigation. There's got to be some basis, the what of the investigation, what exactly happened. Well, if you don't have a policy or a rule to go against, and again, this detective was not trained in EEOC regulations, so he wasn't going there, and there was no internal policy. He basically started an investigation without understanding what the charges really meant and what he had to prove. So because this is a corporate security law course, we have to take the law and understand what we learn from it to apply to our practice, in this case as an investigator. And as we go through the semester, we'll talk about the different phases and facets of a security manager's role and how these laws impact that role. But what we learn from Kramer versus Wasatch County is that an investigator has to have a base of knowledge or experience or they may be a claim of an unqualified, or in this case, the claim was that he was incompetent because he went off on a tangent. He immediately went to, okay, I have a person here. I have to find a bad guy, and then I have to prove that bad guy to be bad. In this case, he chose Kramer. I think she was an easy target because she didn't have a lot of friends in the workplace. Her main harasser indeed did. So that's the direction he went, right? But he had no base of knowledge, okay? There's got to be a policy to investigate. The investigator in a workplace issue normally goes to a workplace policy. If it is indeed a law that was broken, and when you read Kramer, you will see many laws and felonies, intertwined with this case. If indeed you go to read that case, it is not a sign for you to read, so you don't have to, but it's really it's a soap opera. There's no question about it. They really didn't have a policy to investigate because they never really asked for one. So the detective went off not knowing what he needed to prove. If he knew what the proofs or the tests were to show that sexual harassment had taken place, then he would have said, okay, I need to now go ahead and write an investigative plan and find these things. I don't need to find all the rest of the superfluous stuff on the side, all of the innuendo, and I don't need to understand who fathered her child. If indeed it's not part of if that person's not part of this case, right? But that's where the detective went. We also learned that as a security manager, if you're not ready or if you're not able to conduct an investigation, don't wing it. Get outside help. There is no reason for you to worry when you go into your first job. If you are not ready to do a certain investigation, you should be putting up your hand, going to your boss and saying, you know what? I haven't had a lot of experience in this and I don't want to blow it. Can we at least get an outside counsel to assist me, right? To advise me? Or can we assign someone from the HR or legal group to assist me so I can learn how to do these a little better? But don't wing it. When you wing it, you become an unqualified investigator by your own choosing. So be upfront with your boss. I need, second chair is the word that's used in law, right? The extra lawyer that's there to, keep the evidence straight and hand things to the person who's actually doing the courtroom work. Don't be afraid of second chair, and don't be afraid to ask that. So from Kramer versus Wasatch, we learned that you must be a qualified investigator. You must have some policy or something that you're trying to work to find your proofs to see if something actually happened or didn't happen and whether or not it was a violation of that policy. And we also learned that we can't step out of our comfort zone too much when it comes to investigations. We need to get comfortable with them, and we need to ask if something is over our head. There's no shame in that. I know many people come right out of school and go into security and internal jobs where they do workplace investigations, and their first one is always a disaster. I've shared that with my own investigations class, that the first one I did, I was so proud of myself, and there was no violation. So I was starting on poor footing. So don't be afraid to ask for that help. So let's move on to improper and delayed investigations. A two for one whammy on this one. And I found this case to be quite interesting as well. I always get caught up when I do research for classes like this because I start reading court cases, and 2 days later, my wife has asked me, did you go to bed last night? Were you up reading court cases all night? So I did spend a good 8-9 hours reading court cases just to find the right ones that I wanted to use. But it was fun for me. So in this particular case, improper delayed investigations, Smith versus Rock 10. Some of you may have heard of Rock 10. It is I believe they're Tennessee-based, but it is a paper box company. And many of the cardboard box company, many of the cardboard boxes that you get stuff in, right, they're made by certain companies, Uline and forget some of the other names, but Rock 10 makes a good portion of the cardboard boxes used in industry. Fairly large company. And Smith was a worker on a line in a factory. And if you've ever been in a corrugated box factory, and I have, they are very busy places, and there's a lot of big machinery. There's ones that generate heat and certainly compression, certainly all kinds of paper processing stuff. There's big, heavy things, forklifts moving because paper is heavy when you're using it like that. It's a safety nightmare in some cases if you're not very organized and careful. And Smith was working, and every time Smith would bend down to pick something up, one of his coworkers would grab him by the backside. Now, this particular coworker was a man, and he did it to just about everyone. He thought it was funny. He thought that he would slap people on the backside. I'm not sure what his particular aversion or perversion was, but that was his way of having fun. Smith did not find it fun. It was invading Smith's personal space, obviously, and it was inappropriate and unwanted touching. And it certainly was not a safe thing to do, because when you weren't expecting it and somebody grabs you, what do? You jump. Smith made a complaint under the company's harassment policy after several weeks and potentially months of telling this person to not touch him. And the supervisor that he reported to did take the complaint, but said we'd have to wait because the manager responsible for handling these matters is on vacation, so it's going to have to wait. The harassment continued, and nothing was done. And it caused Smith some emotional distress. He basically said to the court, and his story is quite believable, that he was concerned, that he was always on his guard. If you've ever had somebody who is always coming up behind you and poking you in the ribs or something, it makes you jumpy. And he was jumpy in an environment where safety was paramount, and he had more than one, in fact, work error, one where a machine shut down for a good portion of a shift and cost the company money because he couldn't concentrate. When the investigation did take place, it was done by an HR manager sometime later, who spoke to very few witnesses, spoke to Smith and spoke to the person Smith accused, very few other witnesses, and there were many, and then proceeded to document his investigation on a sheet of paper and pen, very cryptically, a one-pager for an investigation into a harassment. Now, again, in our investigations course, for those who have taken it, we talk a lot about documenting investigations and using the investigative plan and how you write up that final product. None of that was done. There were previous reports and complaints around this individual for the exact same conduct. Those were all ignored and never investigated. The person was, quote unquote, talked to, and that was the end. So Smith claimed that Rock 10 failed to protect him, and he left the workplace. He said there was too much mental distress. He could not work, and he was gone from the workplace for a year and a half on mental health issues. He sued the company and was awarded $307,000, which doesn't sound like an awful lot, quite frankly, for a year and a half out of work and compensation for mental distress. But Tennessee has some caps on this. Actually, the cap was $300,000, and an appeals court allowed the additional $7,000 to go through. So let's talk a little bit about Smith v. Rock 10. When it comes to delay in an investigation, EEOC says to establish employer liability, the harasser is a coworker. The plaintiff, Smith in this case, must show that the employer knew or should have known of the conduct and failed to take prompt and appropriate corrective action. Well, we know that in this case, the employer did know. Smith reported it to a supervisor. And the supervisor said, well, we can't do anything about it right now because, the person's on vacation. They also had previous reports of the same conduct to supervision, which were not investigated or recorded. And since those took place in, past months, there was obviously no prompt and appropriate corrective action, and really to protect people's safety and in as much as their own, personal rights not to be touched inappropriately. So based on both the delay of the immediate problem that Smith brought forward and the failure to act on the previous complaints of a like nature, there was certainly a delay in the investigation that would not meet the EEOC standards of Harvard v. Juergen. And so therein lies one reason for the settlement to Smith. But Rock 10, of course, didn't stop there with just, taking their sweet time and not doing anything in the past. But when they did something, they really did an improper investigation. They failed to speak with witnesses. There were witnesses identified, a factory floor, if you've ever worked one, normally you are, in full view of everybody for, the immediate 50 feet or so. And there were a number of people in that area. The way this line is set up, I can picture it in my head because I've been in these factories before with corrugated boxes, and everybody can see. And there were witnesses to talk to. However, the HR professional decided to only talk to the accuser and the accused, and maybe just get some information from others like the supervisor it was reported to. But they didn't speak with witnesses. They didn't document their investigative efforts. They didn't have an investigative plan. They didn't write down everything that they heard. This is important stuff. Obviously, $307,000 is not a ton of money, but it's a loss. And certainly the lost productivity from an incident is disruptive to the workplace. You really need to document an investigation to prove that you did it right. And they couldn't do that. Even if they'd done it right, they didn't document it properly and they couldn't prove it. Smith left for health reasons and eventually didn't come back to work. It was considered a constructive termination. And constructive termination is when an employee leaves on their own, right? I'm going to resign because the working conditions are so toxic that they can't continue. It's really not considered voluntary. And we have all, well, I don't know if you all have, but there are certainly instances in the workplace, and we will look at one coming up here, where a boss just says, okay, I didn't get you on this. I don't like you for some reason. Could be a personal reason, could be anything. But I'm going to make life so unbearable here for you that you will quit. And once you quit, they think, okay, well, you quit the job, therefore you have no claim against me for anything because you left on your own accord. That is not at all true. Certainly, constructive termination can be proven. And so in this particular case, it was proven that Smith really didn't leave on his own accord. He did leave for mental health issues. That was his way of leaving the job. But he was really forced out, and thus the constructive termination kicked in. So using the corporate security law, Smith versus Rock 10, what do we learn? Well, we learn that complaints have to be acted on, and they have to be acted on without delay. The whole idea that, well, I'm sorry, but this guy's on vacation. Well, guess what? Somebody else isn't. And frankly, that excuse from a company the size of Rock 10, which is not a small company, is just, that's just added fuel to the fire. In a small company where, the boss handles everything, right? The owner and the boss handles anything with 10 employees, let's say, and he happened to be away. They may have gotten away with a delay waiting for him to come back to properly do an investigation if he was the only one in a capacity that could do it or authorized a third party, like outside counsel or a private investigator or someone else to come in and do the investigation if it was serious, which is always a way to do it. But the whole idea that, I'm sorry, but they're on vacation, you have to do something. And as a security manager, I would advise you that if indeed a complaint comes in and you're not able to handle it and you go to somebody and say, yeah, well, we got to wait for Jimmy to get back and, he's on sabbatical, he'll be back in, 2 weeks. Go with a plan B. Tell that person we cannot wait. We must do something. Even if it is to put, parties out on a leave with pay. There are some strings that come with that too, but you're doing something to neutralize the situation and to make sure that the person knows that their complaint is being taken seriously. Okay? Investigations have to be thorough. If you have witnesses, you speak with them, and I keep reverting back, and I apologize for those who haven't taken the class, but it's really just basic stuff. You talk to anyone who could be a witness, and then in your investigative report saying, I talked to Bill Jones, and Bill had nothing to add of value to the investigation. The important part is you talk to Bill Jones because he was potentially in the room. He may have seen something, so you talk to him because you were thorough, right? Talk to witnesses. And then document it clearly and in a standard way. Investigation reports matter. We found that from the Rock 10 case. Realistically, when asked to defend themselves, now, quite frankly, there was no defense for the actions they took, but had they at least written it up, they could have cut to the chase quickly and known what they'd done wrong. But in this case, their documentation on the investigation was so bad and so cryptic that they actually had no idea. I can't imagine their company attorney getting hold of this thing and saying, okay, how do I make, lemonades out of these lemons? There's just no way. So documenting investigation is another thing we learn as a security manager from the case law, in particular from Smith v. Rock 10. So we move on to retaliation. And I'm going to speed things up just a little bit because I'm going to try to keep this lecture under an hour for sure. But Colucci versus T-Mobile USA. Now, Robson was a new manager for T-Mobile. He was given this new territory, and Colucci was one of the employees in one of his stores. And Robson, from all indications, didn't like Colucci very much right from jump for some reason. And he asked Colucci to transfer to a mall store. As you know, the cell phone places have, strip mall stores and standalone stores and mall stores. He asked Colucci to go to the big, local mega mall and work in that store. And Colucci rejected the idea of a transfer because he told the company that he suffered from anxiety and that going into a big crowded mall like that every day would simply be too much for him and he couldn't work in that environment. Now, in most companies, especially something the size of T-Mobile, and this was a corporate store, it was a T-Mobile owned store, they would yield to that. They say, what's the, okay, look, if the guy's going to tell us that if we move him to the mall that he's going to quit, we've almost made a constructive termination, right? Because we've made it, and he's telling us this for a medical reason. Normally, companies will just say, okay, leave the guy where he is. Let's just not mess with it. We don't need to pay unemployment to another or medical to another employee. Leave Colucci alone. Robson, however, really took that personal. I'm the new boss, and this guy's telling me he's not going to do what I like. So Robson went out on a personal crusade to find things Colucci might be doing wrong. Well, he did find something. So he was talking to other employees and found that Colucci was using T-Mobile resources for a side business. Colucci had a side business selling used cars. And he occasionally asked employees if people called on his phone to pick it up while he was away and just take the numbers down. And he used the company fax machine, at least on one occasion, if not more, for his own personal use for that business. Okay? So Robson made a quick investigation here. He used the folks from loss prevention. He called them and said, I'm conducting an investigation. I'll need your help for, checking on where the faxes go and who they came to and all the investigative stuff. And he basically, the loss prevention people said, okay, Robson's doing this investigation. We're going to support him. And he supervised the investigation and fired Colucci. Colucci came back with a lawsuit, and he claimed that the firing was retaliation for refusing the transfer and really had very little to do with his personal use of company property, which he admitted to. Colucci was awarded $5 million in the suit, and in an appeal from T-Mobile, it was modified to $1.5 million only because there were certain state laws that in California that set limits on the type of restitution you can get in a retaliation case like this. But he was originally awarded $5 million for this wrongful termination based on retaliation. So let's take a little deeper dive into Colucci versus T-Mobile. Well, we know from reading the court case that Robson really sought out reasons to investigate Colucci. Okay, the investigation didn't come to him. He went to the investigation. And as the supervisor, he said, aha, there's my aha moment. I gotcha, right? Because I've been looking for a reason because you turned down the transfer. They're really based on that turn down of the transfer, though. That's why he was looking. Now, employees use resources for non-business purposes all the time. It happens in every workplace. When you call me on my cell phone, you are calling me on a cell phone that Pfizer Inc. provides to me and pays the bill for. I have unlimited minutes. That we have a company policy that says I may use that phone for personal business, so long as that personal business does not interfere with the company's use of that resource. That's what our company policy is. Same thing is true. I mean, we have a very well-written policy about use of copiers. If I'm in the office and I need to make a copy of a document because I'm going for a bank loan and I need to make a copy, I am authorized, I'm allowed by the policy to incidental use, personal use of company copiers. However, it also spells out that I can't use that same copier to run off 100 flyers for, a bake sale that the Girl Scouts are having, and I happen to be the Girl Scout leader, right? So there was definitely a policy with a company like T-Mobile. And whether or not Colucci violated that policy is really open to interpretation. But employees do use those types of they use company resources for personal things all the time, and it's not always a violation unless you have a policy that says it is. And then we know that Robson himself supervised the investigation. He used the loss prevention agents as a tool for his retaliation. It wasn't that the security people, the loss prevention people, as T-Mobile calls them, were alerted to something and then said, okay, we've got it from here, which is what they should have done. They allowed Robson to continue to supervise the investigation and to direct their actions into investigating Colucci. So what do we learn? As a security manager looking at the case law of Colucci versus T-Mobile USA, we learn an investigation has to be contained to the issue at hand. This investigation should have simply been into whether or not Colucci used company resources for personal gain and whether or not any of that was allowed or disallowed. There's also a progressive discipline policy at most companies, and T-Mobile did have one. It was mentioned in the case. And firing Colucci for a first offense like that was way outside the bounds of their own stated progressive discipline policy. Now, prior bad acts, and in this case, Robson considered the not taking the transfer a bad act. I'm not so sure I agree with that would be a bad act. However, you can consider prior bad acts and bad behaviors in the workplace as part of a termination discussion, but you can't consider them as part of an investigation. So if indeed I'm at work and I steal something and I get caught and I get a written warning saying, if you steal again, you're out of here. And then something comes up missing and an investigation goes on. I cannot use the fact that Brian stole something before as evidence that Brian stole this item today. I must do those independently. Now, if I can prove independently that Brian stole the second item in the second occurrence of theft, then in a termination discussion, HR people, leadership, management who are going to have those discussions can come back and say, okay, this is Brian's second, this first time he got a written warning for theft, and was told if it happened again, he'd be fired, and now we've proven it happened a second time. So it may be considered as part of a discussion once proven, but you can't bring it into your investigation and just assume because I stole once, I stole again. Supervisors cannot be agents of an investigation. They are a witness in this case. They can't go out, and supervisors tend to want to do that. When something happens to somebody in the work group, the supervisor always wants to be part of the investigation. They want to be in on every investigative meeting. They insist they will be there for every interview. No, they won't be. That's prejudicial. Their input really is not based on the facts of the case. It's based on their knowledge of the work group. You can get that by talking to them and understanding it, but they can't be agents of the investigation. The security manager or investigator needs to understand the relationship between the complainant and the accused. In this particular case, had the loss prevention people had independent investigative abilities in this case, they would have likely known that Robson, when they talked to witnesses, that Robson didn't like Colucci because he didn't take the transfer and Robson was the new boss and thought he was being disrespected. But that wasn't done because Robson was leading the investigation, so those steps were left out. And the security manager investigator, in this case the loss prevention people, have to remain objective. They can't work as an agent of either the complainant or other workers. And that goes for victims as well. When someone comes and reports something, you don't look at that investigation as, I'm going to go do this because I want to make, Brian had something stolen and I'm going to go work for Brian. No, you're really not. You're working to investigate a theft and you are going to be objective regardless of who the victim is, who the accused is. You really need to maintain your objectivity. So when we read Colucci versus T-Mobile USA, we see how an investigation can go wrong when someone not part of the investigative team takes control of it, and when a supervisor or others use retaliation and use the investigative process to try to further a grudge, if you will. And so that's what we learn about retaliation. There are literally hundreds of cases on retaliation. So I'm going to move rather quickly through negligent hiring. And negligent hiring really is a subset, if you will, of investigative law, but it is an important part to understand. And we do have one of the cases, at least being briefed this week by the class, will have to do with negligent hiring. And under the doctrine of negligent hiring, an employee is liable for harm its employees inflict on third parties when the employer knew or should have known of the employee's potential risk to cause harm, or if the risk would have been discovered by a reasonable investigation. And that comes from the Society of Human Resources Management, which is the premier trade organization for human resources professionals. And it really is a powerful statement. It really is based on knew or should have known that something that employee could have, has done in the past could come back, right? Now, state laws are really in charge of much of this, and they vary quite a bit. And even the cases between different jurisdictions and different appellate jurisdictions, especially, are a little bit, different. So you really need to look at case law when something comes up with negligent hiring. But most of them prohibit a blanket policy, and they're called fair chance or second chance laws in most cases. So if you have a background check and a person has 3 DUIs, but you're going to offer them a job working in an office, and you don't own any company vehicles, it's, they're going to be a medical receptionist, right? And there are no cars associated with the medical practice other than the doctor's private vehicle, right? Then the 3 DUIs would not be necessarily a disqualifying factor in hiring that person, right? If indeed you were hiring that person in the same doctor's office, but they were going to be responsible for a good portion of the day running medical records between the local hospital and another practice and your practice, and they were going to use a company-provided car to do that, then 3 DUIs would definitely be something that you would look at and say, this is something that disqualifies them from this job. I doubt it with 3 DUIs they'd still have a license, but if they did, even a conditional license, you would have reason to say, I would not hire this person. It would be negligent of me. I can foresee that there's a problem here based on the past history, and therefore I have some liability, and you want to avoid that liability. So we look at case law along negligent hiring. One case that I thought was quite interesting in many facets, and again, I sometimes pick these cases because they have so many twists and turns, but Denton versus Universal AmCan, and by the way, as a Michigander, being border state to Canada, everything is always Can-Am, and in this case, it's AmCan. Bugs the heck out of me, so I'll trip on that one again, I'm sure, before we're done here. But the Dentons, a couple, were injured in a motor vehicle accident. Johnson, who was driving a vehicle under contract to Universal AmCan, was driving in the Chicago area. He was actually in northern Indiana, which matters in this particular case, and weaving in and out of traffic and seriously injured the Dentons in an automobile accident. The investigation showed that Johnson had a significant record of driving offenses and a troublesome history around driving safety. Not only did he have external tickets and accidents, but he also had internal written warnings from previous and current employers about his driving safety. Universal AmCan hired Johnson. Now, they did it through a third-party contractor, but he was still acting as their agent, and they were fully aware of this history. They did a background check. They got the background check and essentially ignored it. And you will find that in some industries, especially where finding people who are qualified to handle a piece of equipment like a large truck, or in other industries where it's just hard to find people to do a job, you will find the tolerance for a background finding that may be related to the job is higher. They will have a higher tolerance for that. It's a dumb move, but it does happen. In this case, vicarious liability attached to Universal AmCan, because universal liability arises where one party is supposed to be responsible for and have control over a third party and is negligent in carrying out that responsibility and exercising that control. In this case, the control should have been that Universal AmCan should never have allowed Johnson to drive a vehicle on their behalf. Right? So by doing so, they accepted the liability, and the company accepted the liability according to the case. So what does this tell us? What does this case really tell us about negligent hiring? Well, background checks. You've heard us say, did he do a background check? You're getting a background check. It's really a background investigation. It is an investigation into someone's past practices, past behaviors, past record of occurrences, and it really is considered an investigation. Security managers are often asked to follow up on things in background investigations. I still get those calls today. Hey, we did a background on this guy, and it says here that he had an assault in California, and then 3 years later another assault in Utah, and then 5 years later. Can you get some information on this? I mean, is this guy just bad luck, or is he bad business? And I will have no problem assigning somebody to follow up with courts, go out and find the records, and understand what the assaults were all about. Oftentimes, you will find in that case that they were related to a domestic issue, which is no excuse for an assault at all, don't get me wrong. However, outside of the domestic relationship with a single person, that person has not had an assault ever. And in that case, you may consider whether or not they would create a danger to others in the workplace. They may only create a danger to that one person who is no longer, in their life and around. And companies make that type of decision all the time. I don't like it. I hold my nose into it. But again, it happens, right? And you're asked to follow up. Or you might even have the function under your control, right? It could be that the security department does the pre-hire background checks or has them done is more like it. You don't ever want to do it yourself, and we'll talk about that in a second. But you need to understand the role that the person is going to do when it comes to, what comes back in the background. If the background comes back completely clear, then you're in the clear. But if it comes back with, again, a DUI, will this person drive on behalf of the company? And you have to be able to anticipate future roles, because oftentimes you don't get a new background check when you get promoted. You can't determine the exact duties of every person in your organization. That becomes key when it comes to background checks and your actions based on things like this particular legal case. So what do we learn from this case and others like it, and how does the case law inform us on our actions as a security manager? Well, certainly background checks are a form of investigation. You should always have them done independently. I will tell you that I actually inherited a security department once that was doing their own background checks, and it was like 10 minutes after being there, it was like, oh, no, contract this out. Get this out of our hands. It's only you. No one's going to pat you on the back for doing a great job in background investigations. They will only get you sued. So you get them done independently. Even the U.S. government just tasks a limited number of agencies. The General Accounting Office will do background checks. DOD will do their own. A couple others, but for the most part, background checks for government jobs are done by a single agency. They don't want all of their agencies exposed to doing this. It's complex. It's time-consuming. Farm it out. As a security manager, farm it out. Security managers are often asked to review pre-hire background checks, and you need to weigh in on simply the facts of the cases that were presented. If they ask you to go look at the case I used as an example, right? 3 assaults across multiple states, across the span of time, and you come back and say all of these are related to a domestic issue with an ex-wife that the person has divorced now for the last, 10 years ago. There have been no incidents since. You don't then say, I don't think can be, I think we can hire him. I think he's going to be okay. You don't offer that. Stick to the facts. The employer can be held liable if they knew or should have known an employee's history might reflect future actions. Vicarious liability is real, and it certainly can cost you money. And don't make the determination of fitness yourself. Again, you verify and get the facts if asked. But in the case of Johnson driving that truck, had you been the security manager and said, yes, he's got these tickets, but the oldest one was 3 years ago, and he's been driving safe since, from everything we see here, I think we're okay. You now have created that vicarious liability through your own opinion. Don't get yourself caught in that trick box. So some takeaways. Investigations are rife with legal traps. We learn from case law that organized, timely, fair, impartial investigations can be defended. But if you don't organize them, do them quickly, right? Prompt was the word used by EEOC. They must be fair and impartial, as we learned from Colucci. That they're not necessarily fair. They have to be timely. We learned that from Smith v. Rock 10, right? Investigators must have some level of competence. We learned that from Kramer versus Wasatch County, right? Don't overplay your hand. If you don't have the experience to do a particular investigation, you've never had any experience doing it, and you don't feel comfortable doing it, don't do it. Raise your hand and tell your employer. It is better to ask permission than it is forgiveness in these cases, right? Ask about getting third-party investigator in to help you, or somebody who's a trained investigator in your company to sit and you be that second chair. Any perceived retaliation has to be monitored, and you must act upon it. The case of Robeson, he took full control. If the security department were allowed, the loss prevention department were allowed to do the investigation independently, they would have seen that right away, I'm sure. Complaints are not fine wine. They don't get better with age. They have to be acted on, and they have to be acted on quickly. And you will be an intake. And we see in these court cases that when you don't do it quickly, it comes back to haunt you. In this case with Rock 10, it was only 300,000, and there were other cases, but that number was controlled by state law. There are much bigger cash awards given in lawsuits based on delays in investigations. What else can we take away from this? Well, prior bad behaviors and acts. You can consider those as part of the disposition of the case. What are you going to do with this guy, right? Brian stole twice, so Brian's going to go. But you can't do it as part of the investigation. When you bring in those prior bad acts and consider them, that's when you have trouble. Do your investigation totally independent and based on the facts of that matter. We learned that negligent hiring can be costly. By the way, I didn't tell you, but the Dentons were awarded $54 million for their injuries, paid for by Universal AmCan, right? Now, just a little extra on that case. They filed the case in Illinois because that is where the company was headquartered, and that is where Johnson was licensed, and that is where he was hired, and they were awarded the $54 million. The accident actually took place directly across the border in Jasper County, Indiana, and Indiana's laws did not allow for that size verdict. There was an appeal on that number. If I'm not mistaken, it was reduced to $35 million. We're still talking real money here. I think once you get over, $20-30 million, now it just becomes crazy money. And so negligent hiring may not have cost them 54, but it cost them like 30, 35, I think it was actually. So understand it can be very costly. Blanket policies. We learned that blanket policies on background checks are not allowed. You have to really look at past convictions and match them with your planned position, and you need to understand how your state lines up with that. Each state has laws on what you can and cannot consider in a background check. Don't be the adjudicator. Find the facts, especially on background checks, and have hiring managers and HR make the decision on whether the person is acceptable or not. You are not making a determination of acceptability. You are clarifying the record as to the facts of a case, if indeed you are allowed to even do that. If you can get that information, sometimes it's sealed. Sometimes police departments and courts will not give you any information, but that's all you're doing. So from court cases and from negligent hiring cases, we learned that you really need to not be the adjudicator. Don't be the decider. Let somebody else do that. Let somebody else decide if vicarious liability is going to attach in the future. Don't hang yourself out to dry on that. So for the rest of the week, there's some reading, and there's just a few pages. You're going to read your court case that you're assigned, but there's just a few pages on negligent hiring and a few pages on investigative law. I think we're talking like a total of 5 or 6 pages, and then your case. The lecture's done. I went a little long this week. I'll try not to do that in the future, but I get excited talking about this stuff. You have a discussion due this week. You're going to write a case brief, and it's going to be individual. You use the first letter of your last name and find the case that's assigned to you, to your group. That's what you will brief on. You will not see the court briefs of others until you file your own. And then once you do that, and you're going to use the IRAC method that we talked about last week, and in last week's work, there is an example of that. I'm trying to remember which case I did. I think it was the Brinks case. Yes, it was the Brinks. See, I'm not going to test you on the names of these cases because I can't remember them all myself, but it was the case where the weapon was issued to one person, they lent it to someone else, that person committed a crime. I wrote an IROC brief on that. I added the example section, which is what you're going to do as well in your assignment. It's all written up in the discussion board. Then you're going to be responsible for reading at least one brief on each of the cases. There's 5 cases that are being briefed. You're going to brief one of them, but you're going to need to read somebody's brief on the other 4 because you are responsible for those cases. Or you may read the full court case if you want to. They're in the text. And they're not hard reads, and they're not long reads. They're rather short opinions. But you are responsible for those, and I want to make sure everybody understands that. Then you have 2 responses due by Sunday, and you're going to give additional examples, and it's all spelled out in the discussion. But you have the initial due on Thursday at midnight, and then the responses due Sunday at midnight per our normal, pattern. This week I'm going to form groups for our week 14 Zoom calls, and I'm going to assign a team leader. At least I'm going to ask people to be team leader. That will come with some benefit to you if asked, but I want to make sure that we have plenty of time. We're in week 4. We're talking about week 14, so you have 10 weeks advance notice as to when your team has decided you'll get together with me for about a 30-minute Zoom call. So if you receive an email from someone who is your team leader and you're assigned to their team, and I'll put the teams out and the team leaders' names out, a phone call or an email and saying, when do we want to do it during this particular week? You all need to decide on a time. I'm going to take that entire week off of my day job so that I'm available to you 24 hours a day. I don't care when your group wants to meet, be it 3 p.m. or 3 a.m., doesn't matter to me, but you will need to be there. If for some reason you cannot reach agreement with your group for that week, then let me know that as an individual that you have met with your team leader and you can't meet because the times the group has chosen. I will assign you to another group, but you do need to be present for one meeting with a group. So just understand it's 10 weeks away. That should give you plenty of time. So I will reassign you if you can't do that. And then the most important part is have a great week. I went a little long. I promise not to do that in the future. At least I will try not to do that in the future. I promise I will try. With that, have a great week, and I will see you on campus.